Thank you very much for joining us today. My name is Ian Scott, and I am the founder of Scott Legal. And today we are going to talk about the individuals who have an E-2 visa and want to consider moving to a green card. A few things before we get started. The firm is a full-service immigration law firm, but also an immigration law firm that was founded on an E-2 visa. So in the United States on an E-2 visa, so know what you are going through when considering moving to a green card or the various options. And we have worked on converting a number of applicants who wanted green cards to green cards from an E-2 visa. So definitely, some interesting topics within this presentation. To the extent that you have any questions, please feel free to add them to the chat function or the Q&A function. We will get to all questions. We may not get to them as soon as you list them, but we will get to all questions by the end of the presentation. The other thing is this webinar is being recorded, so we will send you the YouTube video of the webinar along with the PowerPoint presentation and also a guide to some of the different visa options and green card options that we're going to talk about today. And the final thing we'll send you is a link to our consult to set up a consultation to the extent you want more information. The other thing I wanted to just touch on is that while we do go through a number of different visa options, we do have separate webinars on most of these visa options. So we're going to go through 4 or 5 of them today, but we do have a separate webinar for these that you can sign up for, because we touch on the highlights today, but during those separate webinars, you might have 45 minutes to an hour just talking about that particular visa option or green card. So without further ado, let's jump right into it. And first and foremost, let's just talk about how the green card system works in the United States, because it is a bit different from the way that it works in many other countries. So in the United States, there are green card categories, and they're broadly broken out into family-based categories and employment-based categories. There are some others that we will touch on, but those are the main categories. Now, some countries have what's called a points-based system where you get points for a number of different things, for speaking the language, for how long you've maybe been in the country, for your educational background, your age, different things you get points. And once you reach a certain number of points, you are entitled to apply for permanent residency. But that system doesn't exist in the United States. And instead, the system that exists in the United States is a system where they have a number of different green card categories, and if you're eligible for them, you can apply for them. So it does make it a little bit more difficult because the categories were developed a long time ago and they all have very specific criteria. And as I said, they're broken out very generally into family-based, and family-based is further broken down into immediate relative. What the government considers is immediate relative, which is an immigration term, which is U.S. citizen sponsoring parents, U.S. citizen over 21 sponsoring parents, and individual who's in the United States who is a U.S. citizen who's sponsoring their spouse. And then the preference-based categories will be other categories. They're still relative-based categories, and one would even argue that they're immediate relative-based categories, like a sibling U.S. citizen sponsoring their brother or sister, but those are preference-based categories, and those categories have some drawbacks like wait times and things like that, but we'll get into that in a bit more detail. And then the employment-based green cards are broken out into 5 different categories, category 1, EB1 through EB5. And we're going to touch on each of these as we go through the presentation, each of them except for EB4, which is a religious-based category that our firm really doesn't do any of those. So first, let's talk about family-based green cards. A lot of our clients who are E2 might meet the love of their lives and marry in the United States, and that person might be a U.S. citizen. So that's an excellent way to move to a green card. The immediate relative category is a great one because there is no backlog. So the visa category itself is always current. So it means that you can always apply. There's always a green card available, and you will be able to get that green card. So that we've been seeing some really fast, even under a year, turnarounds with some clients with respect to how fast they've been able to get the green card. So that's the immediate relative category. And as I said, that's one example is the spouse, U.S. citizen marrying an E-2 visa holder in this case. Then we have the preference-based categories, and those might be U.S. citizen parent that wants to sponsor their married son or daughter over 21, and that's a preference-based category. Now, the issue with the preference-based categories is that those particular categories are not always current, unfortunately. So what that means is that those categories may have a long wait. So before you can get the green card is what I mean. So for example, if you are a U.S. citizen that is sponsoring their spouse, sorry, U.S. citizen that is sponsoring their brother or sister or sibling, the U.S. citizen, the sibling's green card would not be available for 14 or 15 years. And when you file the petition, the sibling is not afforded any immigration benefit during that time. And all of the preference-based categories are backlogged. Even the preference-based category of green card holder and sponsoring their spouse is now backlogged. So definitely that's the problem with them. But we do still have, we had a case where we did an E-2 visa for an individual, and his mother had filed for him quite some time before that, and she was a U.S. citizen, and his E-2 was approved, and it was approved for 5 years, but he was eligible to apply under his mother's preference-based category after 3 years, and he did that, and he now has a green card. So that's definitely one category. And we talked about the backlogs. So in terms of the process, and this process is going to apply to each and every green card that I talk about. So it's a 2 or 3 step process. So when it's a 2-step process, then the first part of the process is going to be applying for the benefit based on your eligibility. So if you're family based, you're going to file an I-130, and that is going to say I'm marrying a U.S. citizen. It's going to say I'm sponsoring my sibling, who's I'm a U.S. citizen. I'm sponsoring my sibling, etc. So the first part of the petition is always going to be that objective part. Now, the second part of the petition is going to be either consular processing or filing an I-485 petition, and that's something called adjustment of status. So consular processing is getting the green card outside of the U.S. Adjustment of status is getting it in the U.S. Now, the thing to keep in mind is that neither consular processing nor adjustment of status can be done if the visa category isn't current. So you could have, an I-130 filed for a sibling-based petition. It could be approved, and it could be sitting there for 5 years, for 15 years without the ability for the sibling to do anything. But and as I said, it's always going to be a 2 or 3 step process. I described 2 parts of the process. The third, in some cases, the third part of the process is you get the green card and you have to remove the condition. So for example, under the immediate relative category, if you marry a U.S. citizen, then after having the green card for 2 years, you have to file paperwork to show that it's still a bona fide marriage. So there's, in some cases, that there can be a third part of the process as well. There aren't many where that's the case, but in some cases that can be a third part of the process as well. So we talked about the family-based categories. So now let's take a look at the employment-based categories. So we're going to look at EB1 first. So EB1 is a category, it's a green card category that says that the individual has extraordinary ability and they've really risen to the top of their field. And while this one isn't as common as some of the other ones in terms of, when moving people from E2 to a green card, this one is maybe a little bit more common when someone has an O1 and they're moving to a green card. We have done it in the past, and what we've done is it's a bit hard to see, but when you have the slide at home with you, we've highlighted kind of 4 areas here: evidence that you've been asked to judge the work of others, evidence that your original scientific, scholarly, artistic contribution is major in the field, and there are two others that we've highlighted that are typically the ones that we might use for an E2 applicant. And now because what you have to do is you have to meet at least 3 of, like, there are 8 things listed here, and you have to meet at least 3 of them. So that's how this category works. The one benefit of this category is that you can actually self-petition, so you don't need a sponsor to petition. You can you don't need a sponsor to petition. You can you can file it on your own, and that has some benefits because you don't need a job offer, etc. So that's definitely better. And we do, as I said, it could be that some of the things that we're utilizing for an entrepreneur, and it's again someone that's on an E2 visa, is the person's been accepted to incubators. They've been given funding by major investors and things like that, and those can all be used to show extraordinary ability. And we talked about this particular one is the 2-step process. So the objective part of the process is filing an I-140. So the I-140 is showing that you've actually met at least 3 of the criteria that are listed above, and the I-485 or consular processing, depending on whether you're in the United States. And one other thing to point out: when you are in the United States and you file an I-485 petition, you can file work and travel. Well, and if you're permitted to file the I-485 petition, you can file work and travel authorization as well, which is quite beneficial because the work authorization can be approved sometimes in 3 to 6 months, and then the travel authorization can be approved in that takes a little longer, but up to a year. So the next category we're going to talk about is EB2, and EB2 is one we do a lot of moving people from E2 to EB2 because it's a great category, for this. And as I said, we do have separate webinars on EB2 National Interest Waiver, in particular for entrepreneurs. So I definitely encourage you to check those webinars out. They're on the YouTube channel, but they're also future webinars that are scheduled. And what this is based on is three-pronged test that you have to meet. So the first is that you have to show that what you're coming to the United States to do is of national importance, right? So that can be that it's to create jobs, and it's not 3, 4, 5 jobs. You want to definitely have 20, 30, 40, 50 jobs, a lot of jobs that you're going to create, or some other economic benefit. Or in some cases, we've been able to use what the individual his business is, because we've said that whatever the business is, that particular business is something that benefits the U.S. economy. So there's a famous case that we often use for entrepreneurs, and when we're doing, moving people from E2, and it has to do with an individual who was starting a small consulting company, and he was providing kind of consulting services to vets to integrate them back into society. And so we were, in that particular case, we would use, maybe the business and maybe show that the business is going to hire U.S. workers, but we would also use the fact that what the person was doing to show that there is some economic benefit there, that there is some economic benefit there, social and economic benefit there that the government finds important, because the government actually publishes lots of things that say that they believe that this is important. The second part of this is that you are well positioned to advance the endeavor. So we're going to point to the individual's background. We're going to point to track record. That's going to be very important. If it's an E2 business, we're going to show that the business is already established. The business has lots of contracts. We show their tax return, showing that they're already, well on their way to achieving whatever it is that they said that they were going to achieve. We might show that the business is well funded. So all of those things we show, and in particular, if it's an entrepreneur, moving to a green card. And as I said, we've been very, very successful, even in cases where we've initially, had consultations with people, and the case, we advise them, it's a possible case, but it's a risky case, and even those ones we've been quite, doing quite a good job with. And then the final argument is that the final prong is that the government should waive the labor certification process. So we use a lot of the same arguments that we use for prong 1 and 2 to advance that particular argument. One thing to keep in mind with national interest waiver, and we get a lot of people who set up meetings with us, and they think that there are these threshold criteria for EB2, which say that you either need an advanced degree or exceptional ability. And this is exceptional non-ability, not extraordinary ability that we talked about in the last slide. And then they list 7 criteria for exceptional ability. And a lot of people make the error thinking that if they meet those threshold requirements, that they're eligible for EB2 national interest waiver. But they're the requirements that you have to meet before you start going to what I just talked about before. So if you either have an advanced degree, which is a master's or higher, or a bachelor's plus 5 years experience, or exceptional ability. And if you have one of those, it's either or, right? So, but if you have one of those, then now you move to step 2, and you go to see if you meet the 3 prongs. So that's something to keep in mind. Now, the next way that a lot of our clients move to green cards has to do with companies sponsoring them for a green card. Now, your E2 company can't sponsor you or your spouse for a green card, unfortunately, because the ownership interest, the E2 company, you own at least 50% of the company, so that's not possible. But we have had in a lot of cases is individuals where their spouse who has work authorization, he or she has been able to get a job in another place, and then that place has sponsored them for a green card, and then that the E2 visa holder is able to get the green card as well. So it's, the process is a long one, where a company is sponsoring you. They're going through what's called a PERM process, where they're dealing with the Department of Labor to show that they can't find a qualified U.S. person. But it is a way that a lot of our clients move from an E2 to an E2 to a green card. And this is similar, like in the 2-step process, where you're filing an I-140 for the first part of the process, and then I-485 or consular processing for the second part of the process. Now, the next kind of category of moving to a green card is again one we do a lot of, and this is the EB5 category, where the individual can use their E2 business, their current E2 business, and use even the investment that they made in their old E2 business to get a green card, right? So so this has a few requirements. So one, unlike E2, this has a very specific investment requirement where you have to invest either 800,000 or 1,050,000 in a new commercial enterprise. The amount is going to depend on whether the business is in a location which is either a targeted employment area, which is either a rural area or an area where the unemployment rate is 1.5 times the national average. And then yeah, the big piece of this is the investing of that amount. And then with the E2 visa, the investment can be made over time. We'd converted one person to EB5 where the individual had invested money over a large, broad time frame, very, very broad time frame, and years, like over 10 years. And that they were able to kind of add up all of those investments. At that time, it was 500,000 to come to that amount. The investment does have to be new investment that's kind of outside of the company and coming into the company. And some differences between E2 and EB5. If your E2 business is a business that you purchased, like let's say you purchased a restaurant, then the purchase price isn't necessarily going to be used in the EB5 investment amount. It's kind of a very complicated area. The other kind of big difference is the source of funds for EB5 is much more extensive than for E2, like far, far more extensive than for E2. So that's something to keep in mind. Another big difference is that EB5 doesn't have any required investment percentage. So that's something that is, you can own even 1% of the company, and that's going to be fine. The other big piece of EB5 is job creation. You do have to create 10 full-time jobs. They have to be full-time jobs for U.S. citizens or green card holders. And if you're doing a new EB5 case, you're going to present a detailed business plan. But even if you're doing using your E2 business, you want to, unless you've created the jobs already, you're going to want to present, documentation showing that you're able to create those 10 full-time jobs in the required time frame. And the process here is a three-step process where you're going to file an I-526 for the first part of the process to show that you've invested the money and show that the businesses can hire the 10 full-time workers, and then either consular processing or I-485. And then after 2 years after you have the green card, you're going to have to file an I-829 petition to remove the conditions, and that's showing that you were able to create the 10 full-time jobs. Some other green card options to always keep your eyes open for. Diversity lottery is one that, every year one of our E2 clients, seems like every year one of our E2 clients wins the diversity lottery, and we do a diversity lottery for them instead of the E2. So as long as your country is eligible, I know that England was added to the list this year. That's definitely something you should consider. And then there's some humanitarian based green cards as well. Like sometimes if you like, for example, helping the police solve a crime, and there's some others like under VAWA, like domestic abuse and things like that. So those are some we in all honesty, those aren't categories that we use very often or even at all. At diversity lottery, definitely we have, but the humanitarian based categories aren't categories that we use that often to move people from E2. However, they should be kept in mind because they're possible. The one thing to always keep in mind with when you're moving to a green card is these kind of timing considerations, because you do have to always maintain status and have some underlying status. And sometimes these petitions, like an EB5 petition, can take 4 or 5 years for the government to adjudicate. So you do have to make sure that you're maintaining status, and that if you have, depending on what you filed, that you are not in a position where you are risking your renewal of your E2 because of dual intent considerations. So the other thing to kind of keep in mind is that there's a lot of our clients do have parallel green card strategies. They might be eligible for national interest waiver and EB5, and they may apply for both, right? So it's NIW is probably a little better because you don't have to remove conditions and there's less monitoring, things like that. And really the key here is planning is key, I think with all of these. So that is all we're going to cover today. There was one question, but let me just see what it says exactly. So yeah, we are going to send some information on how you can connect with us. The yeah, we are going to send some information on how you connect with us. Yeah, and I guess someone attended a webinar on Monday. Definitely I can check to make sure that you get that. If you just send me an email after this webinar, then we can deal with you deal with the questions that you have here. So maybe if you do that, if the person who sent this, it's an anonymous person, so I don't know the name, but if you send me an email after this, if you send it to the info at account, or if you do it straight to me at iscott@legalservicesincorporated.com, then we can deal with those questions. Perfect. So great. Glad everyone could come. And as I said, all of these things you will receive after the meeting. It could be that because tomorrow is Thanksgiving, that it might be that you receive the email next week, because our staff are off both Thursday and Friday. But it might be that it comes today as well. So great. So thank you very much for joining.